Okay, so welcome to the MPW workshop series. Today's presentation will be a law workshop, which will be delivered by Jessie Venegas, and Jessie is our law tutor who is based at MPW London. Today we will also be joined by some students as well, so you will have the opportunity to ask questions at the end of this, both Jessie and to our students. As usual, please, those who have joined us before, can I please ask that you keep your mics on mute? There will be opportunities for you to ask questions at the end through the chat box. So if you do have any questions as you go along, please do write them there. I will be monitoring them and then we'll be asking Jessie at the end. Please also note that this is a recorded session and we will send you the recording later on today. Okay, Jessie, thank you.
All right, everyone. So this is me. I don't know if you can see me. I am going to turn off my video just to make sure that the quality of the sound is much better. And I will put it back on once at the end of the session. But please feel free that I will be asking you some questions and feel free to put them in the chat so Betty can tell me what your questions are. So let's begin with what we're going to cover in this lesson. So in this session. Sorry, I'm so used to teaching. Everything is a lesson. So I'm going to cover four main things. So the first thing is, what is A-level law? So I will give you a taste of what A-level law is, what the subject contains, what the content is like, and explain to you why A-level law would be a good A-level for any student, whether they're planning to become a lawyer or go to law school at university, or whether they are simply unsure on what they want to study. I'll give you a little sample lesson, which I'm trying to make it very interactive, and hopefully by the end of the session, you should be able to know how to draft a legally binding contract in English law by text message. So that if I can accomplish that in this session, you'll get something out of that. And then we're going to talk about what the process is for becoming a lawyer in the UK if you do decide that you want to do law as a career. So what is A-level law? So A-level law is an A-level subject like any other. It is accepted by all universities. It is considered to be a highly challenging academic subject. Now, there used to be a case where there were certain subjects that universities prefer over others. So more traditional subjects like history, biology, chemistry, those sort of subjects. Now, that is no longer the case. Universities are prepared to take a wide variety of A-levels for a number of different university courses. And the key thing is to figure out what you want to study before you pick your A-levels and see what the requirements are. Most universities will just ask for A-levels. A-level law is not a requirement for studying law at university, but as I will explain to you, is actually very, very helpful. So the A-level law curriculum that we do at MPW is OCR. And as you can see here, there are 3 different exam papers. Each exam paper is worth 1/3 of the grade. And in these exam papers, students get a combination of fact-based questions. So they just asked what the law is. They also get scenario questions, which are very much questions of what you would do if you were a solicitor, how you would advise your client. And we cover 3 main areas of law. So we look at contracts law, we look at criminal law, and we look at tort law, which looks at a number of things like negligence, nuisance, vicarious liability, which is a liability between employers and employees. And so you get a really, really good sense of the subject, a broad sense. So why would you pick law? Why would this be a good A-level? So there are a number of reasons why A-level law is a good subject. So the first one is improve your persuasive skills. So your ability to move someone from one side to the other in terms of what they're willing to do. And I will have some students joining us today at about 10 o'clock, and they will tell you some of them have actually learned something, let's say on Monday, and on Wednesday, they have it already using those skills. I think one of them argued something with an online retailer to get a refund for something. And she quoted the law. She drafted an email based on what she had learned in law that week. And she was able to save herself like £200. And they're constantly learning how to do it. I have another student who constantly looks at TV. So she watches a lot of crime drama, and she's in her head going through the steps of what the person would be charged with, how she would defend them in court. So it's actually very practical. It's actually very fun. So negotiation skills. So when you are negotiating in the world of business, you have a much stronger position if you know exactly what your legal position is. So if you walk in and say, well, this is my legal position, where we go from now, and that confidence, that knowledge allows you to get better deals, whether you're going to study business or law or politics. But this is the most important one, and this is one I wish I had done. I wish I had done an A-level in law before I did my law degree, because it would have made my law degree so much easier. So when you go into the law degree, even though there is no requirement for A-level law, there is a number of foundation topics that they don't teach you. So for example, they don't teach you how the jury works, it's elected. These are things that you're sort of expected to pick up from reading the news. A-level law actually gives you a really good foundation on everything, on how the legal system works. And particularly if you're an international student like I was when I studied law, there's a lot of things that are culturally very unknown to English students that I didn't necessarily know. And so an A-level law would give you that foundation knowledge of how Parliament works, how laws are made, how they get passed, how the different political parties come up with the laws that we have, how they get changed. And these are things that international students who are fresh new to the country won't necessarily know that. But at the law degree, they sort of expect you to know it, because a lot of it is based on a foundation knowledge for English students. Now, improving your writing and presentation skills. So there is a lot of legal writing, and there's a very specific skills when it comes to legal writing, because learning law is like learning a second language. So you have what words mean in English, but then you have what words mean in legal English. And sometimes there is very little relationship between regular English and legal English, which is why we ask for a very high level of IELTS and GCSE English to be in an A-level law class, because it's not just, you don't just need to speak English well, you need to speak English and be willing to learn a second English language, which is the legal English language. And so this is really important. But also when you're arguing in a case, if you know the legal terminology, if you're writing to a retailer, if you write everything in legal terminology, it goes straight to the legal department, and the person reading thinks, oh, this person knows what they're talking about. So, they treat you in a particular way. So even though this is not a requirement for any university course, it is a great preparation for business, politics, and law. And the reason I've picked out these three is because there's a little bit of overlap. So a lot of the things that we study in contract law, for example, are very useful if you're going to study a business course. And because it gives you a foundation of the legal limits, and it also exposes you to a number of case studies from real cases that you would probably come across in a business course. It is also very useful for politics, because one of our modules goes through the foundations on how laws are regulated and created, and the powers of government and limits of powers of government. So if you want to do a politics degree, having this foundation knowledge is really, really useful. And as I've said before, it is very important for the law course. So I'm just going to give you a little bit of an example. As I said before, so the first thing is it gives you a foundation of how the English legal system works, in the sense that you get to know how juries work, how magistrates work, what is the difference between barristers, solicitors, how do you train, what the different courts do in the process for appeal. But what's actually the most useful is you get foundation to three courses that are mandatory in a law degree. So that's criminal, contract, and tort. And just to give you a sort of an idea, I took the curriculum for criminal law, first year criminal law at a university. I took this from the University of London, although they are all standardized in the sense that they all have to teach the same things. And if you see, all the things with a tick is things that you cover at undergraduate level for law, but you also have cover that in A level. So once you go into a law degree, you will have a lot more knowledge and a greater chance of getting a good grade than somebody who is doing this for the first time because they didn't do an A-level law. Now, at the degree level, they would go, let's say, they cover a topic at 100%. Let's say at A-level, you cover the same topic, but maybe at 70%. So the level of depth is not as great as the undergraduate. So you're not going to be bored when you go to undergraduate and think, oh, I already learned that. No, because you will go much, much deeper at undergraduate level, but you will have an incredible foundation knowledge, which if I could go back in time to choosing my A levels before I did my law degree, I would absolutely take this because it would have made my degree experience a lot better. Any questions, Betty, that before I move on to the next section?
No, Jessie, we'll do questions at the end. Thanks.
Okay, fantastic. Right. So, now you might think, well, I'm really interested in law, but I don't want to be a lawyer. And I think that's actually very common. So a lot of graduates, one good thing about a law degree is that it's very attractive as a degree because it demonstrates a high level of skill. And most of the graduates from law go directly into employment. So I took this data from the UCAS website. And you will see that the majority go into employment, but some of them who don't go into employment go into further education. And when I explain how the routes for qualifying as a solicitor, you will see that actually 65% going into employment is pretty good when you consider that a large majority of them go through further training so they can qualify as solicitors. So you will have people who enter in professional, scientific, and technical fields because a law degree is very versatile. I learned very early on in my career when I volunteered at the criminals and the criminal court that I loved studying criminal law, but I didn't like the practice of it. And it was a personal decision, but I had no trouble finding a different job and a different career when I realized I didn't want to be arguing in court. But for a lot of people, that is the actual destination. But I've met so many lawyers who do law for a bit and then change careers quite easily. And it's a very versatile degree. So there are careers in trade, retail, public administration, which is, dealing with government, and in the financial sector. So it can be a very lucrative option if you decide to have this knowledge. Again, in health and social work as well is another option that you could move into. So as I said, it gives you a good foundation, you know the basics, and then you can move into any career that you like. So now I'm going to start my sort of sample contract law session, and I had planned this to be a little bit interactive. So I will be asking you to be messaging Betty some answers to the questions that I'll be posing to you. So I want to teach you what a contract is, so that you know how to create a legally binding contract with someone, or how to avoid creating a legally binding contract with someone under English law. So English law is slightly different because it is based not so much on statutes, but what we call the law of precedents, or common law. And this means that when we have a decision made in court, that decision on a particular case is legally binding on all similar cases. And this has been going on for generations. And what that has created is a series of legal principles. So they're not particularly written in one book that has all the laws, but these are principles that we have from tradition. And that makes the law slightly exciting, but also a little bit complicated, because in most countries, you have a codified book that has all the laws. You can open the book and find out the law. In the UK, it doesn't quite work like that. So each legal discipline has a number of principles that you have to learn that are hundreds of years old. So this is why I'm telling you what you learn in this lesson today. It will be one of the lessons in Contract Law 101 at university. So what is a contract? Any ideas? Anybody want to tell me what you think a contract is? I will move on. If there are answers, Betty, you can just let me know.
I will
Right.
do. Oh, we've got Vivian who says it's a legal document.
Okay, fantastic. That is one of the
Binding agreement, Jessie.
Okay, fantastic.
If you just allow 2 seconds, if anyone else is going to type.
All right, okay.
In. An agreement among 2 parts from Beatrice.
Okay.
Rebecca says between 2 parties to agree on some issue.
Fantastic. Right, so let me deal. I like the answer that said that it's an agreement, because that is absolutely right. We tend to think of contract as a legally binding document. And while that's true in many countries, that is not necessarily the case in the UK. The most important aspect in the UK is the agreement. So I have a picture over here. So somebody trying to buy a car. I want you to tell me, do we have a contract here? When somebody says, I would like to buy a car, has she created a contract with that question?
Tatiana says no. Beatrice says not yet.
Not yet. Well done.
No
Yes.
contract is what Chankaho says.
Fantastic. Fantastic. This is brilliant. You are absolutely right. There is no contract there. What about now? She says, I want to see it from the inside. He says, oh, and he gives her the price.
Not
Contract?
yet.
Not yet. Well done.
Verbal agreement can be considered. No,
Okay.
No contract, not yet.
Fantastic. Well done. You guys are so good at this. No contract yet. What about now?
I think that's nobody knows quite yet. I would say yes.
Okay, so let's look at the parts of a contract.
So Vivian says yes. May says not yet. Chankaho says it's a contract. Beatrice says an oral agreement is not a contract.
Okay, listen. So in the UK, you can create a contract without actually writing it down. You do not need a document. Yeah. So an oral agreement in the English law can 100% be an enforceable legal contract. In fact, a contract over text message can be an enforceable legal contract. So you do not need a written agreement. What you need is 4 elements, which I'm going to go through. The first one is the offer. So somebody has to say, I am going to buy your car. Yeah, that they are making you an offer. But the other aspect is we have to have an acceptance. So all of you who have said it has to be an agreement, you're absolutely right. It has to be some sort of agreement. Somebody offers something, somebody accepts it. Now, as you can see, this is a square. So offer is one side of the square and acceptance is the other side of the square. There's 2 more elements on that agreement. And I'm going to show you why. I'm going to show you an interaction when I'm sure that you're all familiar with, if I have any students in the class. So I have a parent and the child. The parent says, I'll give you £100 if you do your homework. Very generous parent. And the child says, okay, do we have a contract? We have an offer, and do we have an acceptance? Do you think that child could take mom to court and say, pay me the money, I did my homework? How many of you think?
Yes, yes, we've got a mixture of yeses and nos.
Okay, so I'm interested in the no's. Why you think we can't have a legally binding contract here?
Let's just give some time to Rebecca, to Chankaho. Child labour is illegal. Okay, that's a good one.
That's a different issue, but it's a very good issue. Thinking like a lawyer already.
Yep. Tatiana says witness.
Tatiana says?
It says witness question mark. Maybe because there isn't a witness.
Very good.
Vivian says to give motivation for the child.
Okay. Some very good responses there. Okay, I have my students have joined our call.
Yes.
I'll call them in a couple of minutes. They are all very familiar with this. Right. So, in order to have a legally binding contract, we also have to prove that the parties making the agreement had a legal intention to be bound by that contract. So they have to have an intention to create a legal relationship. right? And so there are two things that we look at. So we talk about presumptions. A presumption is what we assume before we have evidence. So if it's a domestic agreement, so if it's between friends or family, we assume that people didn't want to be taken to court for that agreement. We assume they didn't have any intention of creating illegal relations, unless we can prove, and this is where the witness, somebody mentioned the witness is important. We can prove that that person intended to be bound by the agreement. Now, we can also have a commercial situation, and a commercial situation is when you go to a business or a restaurant, a hair salon. We assume that you intended to be bound by the contract, even though you may not have said it like that. So you intended to create illegal relations. And I will give you one example, and I'll stop so that my students can talk to you and give you some information about what the course is like. So I don't know if I'm too old, and I hope that you know who these two people are, if there's any students in the crowd. But these are Joey and Phoebe from Friends. Yeah, so they're really popular. I'm hoping that you still know who they are. But here we have Phoebe giving Joey a haircut at home. Now, this is a domestic situation. So we assume that even though there is an agreement, maybe Phoebe said to Joey, yeah, I'll cut your hair. We assume that she doesn't intend to charge him. So she doesn't intend to get paid for that. And because of that, she can't take Joey to court if he doesn't pay her, because that's the assumption. It is a domestic agreement, it's an agreement between friends, right? However, she does not have to pay for so Joey doesn't have to pay for the haircut unless Phoebe can prove that Joey said he would pay for it before he gave her the haircut. So it has to be agreed before. Before she started, he should have said, okay, I'll give you £50 for the haircut. In that case, she would be able to get paid, but she needs to be able to prove it. And so how does she prove it? Ooh, I hear somebody's microphone. So how does she prove it? She proves it because she has a witness or because she has a written agreement. Yeah, so this is where the written agreement becomes important, not because it creates the contract, but because it's evidence of the contract. I hear a microphone. Can everybody make sure they put themselves on silence?
I think most people are on, everyone is on mute, so I don't know where that noise is coming from.
That's very strange. Okay. Right, so we have, if I go into the hair salon and I sit down, get my hair cut, but we don't agree on a payment, we don't agree how much it's going to cost me, I can't then say, well, we didn't agree on the price, I'm not going to pay, because it's a business setting. So we assume that the client has to pay unless the client can prove that the salon said they didn't have to pay before they sat down. So if I have a voucher that says free haircut, you don't have to pay, then I don't have to pay because there's no intention of creating legal relationship. But this is how the assumptions work. So in a domestic situation, we assume that the person doesn't have the intention, and in a commercial situation, we assume they do, but the evidence will prove one way or the other. All right, so I'm going to stop here for this point before I move to the last element of contract, just so that I can bring the students in. So do I have Zara and Lucy on the line?
Yeah, hello.
Yeah. Hello, hi.
Hi.
All right. I was telling them about you guys because I will start with Zara first, because Zara is the student I was telling you. Learned something on a Monday. By Wednesday, she was already applying it. Zara, do you want to tell us a little bit more about that?
So I had made an order to the White Company for some kind of bed linen and that type of stuff. And I paid for next day delivery, all the other stuff, and we just learnt about contract law. So I was a little bit upset when it didn't come the next day. My sister was leaving for work and everything else, and I needed it by then. So I sent in a complaint, and I was talking about kind of what product it was and all of that stuff. And then by the end of it, I made reference to the Consumer Rights Act of 2015 and the breach of the description of the delivery. and basically mentioned that we did have a legally binding contract, the money had been transferred, everything else. And by the following day, I'd have with my product sent to me and money back from the next day delivery. So overall, it was a win.
Good. And
Zara,
Lucy, yep.
Sorry, can I just ask Zara a question there? Zara, did they not come back to you and say because of the COVID-19 situation that 2015 agreement wasn't sort of binding at the moment?
That was just actually before the big outbreak. It was when we first started contract. So I would say it was probably like a month or so, maybe 2 months ago. 5th of March.
I see.
Just pulled it up now. There we go.
Okay, great. Thank you.
And Zara is actually going to be studying in the US. Zara, do you want to tell us a little bit more about your experience in law and what you hope to do in the future?
Sure. So I was introduced to kind of the criminal legal system when I was quite young, and decided that that's kind of something I wanted to go into. MPW appealed to me because it offered law, which I couldn't find at any other school, and pretty much decided that university in the US offered kind of many more options because it will reopen all the doors in my first year, and hope to then move back to the UK to finish my law degree.
Okay. All right. So I'm going to move to Lucy. Lucy has this ability of constantly applying the law. Everything we learn, she immediately has an example of something. And Lucy, you had an issue with your neighbor and a fence. You remember that? You mentioned that to me. Do you want to tell us a little bit about the issue with your neighbor? Do you remember what I'm talking about?
Yeah, we were talking about private nuisance, and obviously that's like for you and your neighbours. And you were saying that if there's been a nuisance for over 12 years,
20.
then you can't then after the 12 years take them to court. So I was saying that my fence was always falling down between mine and my neighbour's house, and it's kind of a nuisance for us because then we always have to pick it up, and he's not really ever home, so we have to then sort it out when actually it's his fence. So I was asking Jessie what we can do about it, but because it's been after the 12 years, we can't really do anything about it because we've been putting up with it for so long.
Yeah. And Lucy, would you want to tell us a little bit about your experience in law and what you hope to do? Because I'm planning to study law at university.
Yeah, so I'm really interested in criminal law, and so at uni I'm going to study law and criminology. So that's basically just about criminal law, and then in the future, hopefully, I want to become a criminal lawyer. So that's what I'm really keen to do. And everything on Netflix that I watch is about criminal activities and stuff like that. So I'm constantly applying the law when I'm watching Netflix, which is a bit annoying, but it's quite useful as well. So.
Yes, and Lucy always brings cases, very bizarre cases. One thing that you do get in law is we get a lot of really bizarre things because people do a lot of really crazy things, and then we have to analyze it and pay attention, break it down to see what the punishment would be. Is there any questions for Zara or Lucy? Is Jack on the line by any chance?
I haven't seen Jack.
Okay, fair enough. Any questions for, because I know Zara needs to get back to her lesson. She's in the middle of lessons, and Lucy is doing a lot of revision at the moment. So is there any questions for them at this stage?
Not at the moment, but if anybody does have any questions, please do write them into the chat box, and we can ask Zara and Lucy afterwards, and then we can get back to you once we send you the recording as well. Zara and Lucy, thank you both so much for joining us, and good luck with your classes today.
Thank you.
Thank you very much.
Bye.
Okay, so let's go back to our elements of a contract. So we have learned so far 3 elements of a contract. We know a contract needs to have an offer, we need to have an acceptance, and we also need to have an intention to create legal relations with 2 presumptions. So if in a social setting, we assume people didn't want to create a contract unless they have evidence. And in a business setting, we assume they wanted to create a contract unless we have evidence that proves they didn't. Now, what is the if you're dealing with your parents, so your parents say that we're going to do something for you, how do you make sure that your parents' promise, I'm talking to the students in the class, it's legally binding in English law? Any ideas? How do you keep your parents to the promise?
Well, Vivian has asked if that's bribery or not. So,
well, a contract, the beauty about contract law is that parties can agree with everything they anything they like. So the law doesn't interfere on what you agree. If one party wants to give you £100 for your shoes and you're willing to give the shoes for £100, then that's fine. It doesn't get interfered. They don't really look at whether it's worth that or not. So my message to you, if you want a contract with any member of your family to be legally binding, you need to get it in writing, because it's a social agreement and the court will presume that they did not intend to create a legal relation. But if it's in writing, then they are more likely, that's not 100% of the case, but they are more likely to rule in the favor of a person willing to say there is an agreement. I'm not going and suggesting ask your parents for £100 for doing your homework, because we will look at the other element that might not necessarily work. But in general, if you're making an agreement with a friend or a member of your family, get it in writing so there is no issues. Now, in a business setting, it's usually better to have it in writing, because even though we can prove there is a contract, sometimes it's really hard to prove what is in the contract, what exactly people agreed, which is why most contracts end up being a document. But the message is that the document is not strictly speaking necessary. Now, I have here, there is a couple, they go to a car dealership and the guy says, I will sell you a car for £1. And the couple said, yeah, great deal, I'm going to accept it. Is this contract a legally binding contract? Any ideas?
Rebecca says no.
Okay, why not, Rebecca?
It's too good to be true. Chan Kaho says yes.
Okay.
Wheeling
right.
says yes.
All right. So, Rebecca, you're absolutely right. It's too good to be true. Unfortunately, it is a legally binding contract because we need to have something called consideration. That's a fancy word for just means something of value. And money, regardless how much money is, it's always something of value. So sometimes you will see companies, people who buy a company for £1, or you say, what's the point in that? The point of that is that it creates a legally binding contract, because unless there is an exchange, so both parties get something out of it, that contract is not legally binding. So in this case, the law doesn't say, well, a card is too cheap for £1. If two parties are willing, one party is willing to sell a car for £1 and another party is willing to buy it, the law is not going to get involved in that. It's a freedom of contract if that's the one to agree. If somebody wants to make a bad deal, it's their bad deal. So here we have the 4 elements of contract. So we have an offer. Somebody says they want to buy or sell something. We have the acceptance. We have the intention, which can be in its domestic setting or in a business setting. And we have the consideration, which means something of value. And that could be a lot of things, but money is always good, because money, nobody can agree that is something of value, whether it's £1 or £100. Okay, so I'm going to be, here we have Phoebe again. Phoebe is really upset because she gave Joey a haircut and she wanted that money and he's not paying her. So the question is, Phoebe comes to you, you're her lawyer or his lawyer, you're her lawyer, and she shows you this text message. I don't know if you can see it on the screen. Joey sends her the message afterwards, says, that was a great haircut, Phoebes. I'm sorry, I thought you thought I was going to pay you. I don't want to lose your friendship, so I'll give you £50 when I get paid. Now, Phoebe says, here, I have the evidence. I want to sue him for that money. Well, what do you think do you think Phoebe will be successful in court? Any ideas? Any answers from that? Anybody typing?
Wheeling says yes.
Good. Why is that, Wheeling?
And then Beatrice says no because domestic. Chankaho says no because admissible support.
Okay. All right. So the key thing here is that Joey only agreed to give the £50 for not to lose the friendship. It wasn't for the haircut. It was not to lose the friendship. Arguably, you can say a friendship for £50 is not an exchange of something of value. So there's a problem there. The second problem is that he told her he was going to give her £50 after she gave him the haircut. And that is not consideration, because consideration has to happen before. So even though she has a text message, that text message does not help her in court because it was an agreement after the fact. So consideration has a number of rules. Yeah. First, you can't get something for nothing. So if you don't give something of value, you can't get something of value. Therefore, you can't enforce a contract. Second, you can't get paid for something you did for free and then somebody agrees to pay you. So if I say to you, I'll clean your house, but I wasn't doing it for money. I was just doing it as a favor. And then I ask you for money, then that's not a contract because that happened after the fact. You can't get paid for something you did, but nobody asked you to do it. So if I went out and then started making beautiful paintings, and then I said to my boss, you have to pay me for those. Well, no, because he didn't ask me to make them. So I don't have to get paid for that. You also, and this is the key thing, and this is why the homework thing might not work. You can't use consideration for doing something you're already supposed to do. So if your parents said to you, I'll give you £100 for giving the homework, you have two problems. The number one problem is intention to create legal relations because they're your parents. So unless you can prove it, that's a bit dodgy. And also the court could argue that doing your homework is your obligation. So being paid to do your homework, you're not really doing anything extra. So it's not a good consideration. Now, we have all the offers: intention, acceptance, consideration, and offer. Now, this would, if you were doing the law degree at university, this probably will be your first lecture, and you would already know what these things mean. Okay, so here we have a text message, and I want you have somebody comes to your office, you're their lawyer, and they will say, well, here's my contract. This is a text message. Can you help them? Is there a legally binding contract here? Look for the 4 elements. So do we have offer, acceptance, intention to create legal relations, and consideration? Any ideas? Is anybody typing, Betty, that we're waiting for?
No, we just need to give a few more seconds.
It's all right.
Beatrice says it is a contract by common law. Vivian says yes.
Good. Any no's out there?
Rebecca says yes, but the contract details are not clear.
Okay.
Chankaho says yes.
Fantastic. Great. Well done. All of you were absolutely right. So here we have the offer. When somebody says, I want to buy it. So there is a thing that I didn't go through in this session, which is a little bit more complicated, something called an invitation to treat, which comes before an offer. But don't worry about that. If you were in the law lesson, I would go through it, but we don't have time. But here we have an offer, we have an acceptance, we have consideration because it's £1,000 in exchange for a car. Now, the one thing that might give you a little bit of difficulty is it with dad. So the intention to create legal relations. That could still be a question. So we have it in text message, so we do have the evidence of it. But if you were to court, the court will look at something called the balance of probabilities. So the judge will look at the case and say, what is most likely? Do you think it's likely that dad was intending to create legal relations? I think in this text message, you're probably right. It's more likely than not that the dad was trying to create legal relations. Okay, final example. just to check everybody's learned it, do we have a legally binding contract here? Betty, are we waiting for people to type? Because I can't see the chat.
Yeah,
okay,
there was a delay in your slide.
Oh, okay, no problem.
Beatrice says yes. Chankaho says no. Rebecca says Delon.
Okay. All right. So this is an interesting one because sometimes in an A-level law, you don't get clear-cut answers because sometimes it could go one way or the other, and that's why you end up needing lawyers. So let's look at the example. Would you like to buy my? Would you buy me a car if I get an A-star in law? That could be an offer. Yes, that could be an acceptance. Great, I will work hard. So definitely a contract there. What about the tutoring? What if I tutor my sister too? I'll give you £100. So that's a second contract, potentially. Now, one thing that would be difficult is that the judge might say, well, getting an A-star in law is your duty, so you're not really providing consideration. You're supposed to do that. Although getting good grades is probably the duty, getting an A-star is probably more than that. So there's a room for argument. So that first contract is not very clear cut. So if you said yes or no, you're probably both right. And all that matters is how you defend it. So if you want to say that there's no legal contract, you will say, well, actually, getting an A-star in law is not good consideration because you're a student, you're supposed to get the best possible grade, and that's not legal consideration. There's also the issue that you're dealing with mom. So we don't know if mom really intended to create legal relations. Now, if I have any parents in the room and you're thinking, oh no, what is she teaching you? So I'll give you something for you. If you ever have any chat conversation with your children like this, all you have to do is write down a text message that says, but I have no intention of creating legal relations. So even though you might have a legally binding contract because there's offer, acceptance, consideration, if somebody says, I have no intention of creating legal relations, then there is no contract. Yeah. Also, be very careful if you ever sign a contract that has a term in it that says, this is not a legally binding contract. You might not think that happens, but it has actually happened and it's actually been successful in court in the past. There is now legislation that prevents it from happening, but just be very, very careful with that. Okay, so thank you very much for those of you who have been interactive. And I hope that you have got something out of it. As I said, we have set up what a contract is. The reason we need contract in writing is because we need all other things that go inside a contract, like terms, conditions, warranties, express and implied. All of this will be the second session that we will go through, what this means and what the implications are, which we don't have time to do it. But I hope you have enjoyed that. So I'm going to move on to the next aspect. So if you want to become a lawyer in the UK, so lawyer tends to be more of an American term. In the UK, we talk about solicitors and barristers. So a solicitor is in the UK, you can be you study law and you go into two different areas. So a solicitor is somebody who works for a law firm. So they're usually salaried, means that they get paid every month. They have a lot more support and security because they work in a firm. There's a lot of rules that comes with being a solicitor. You probably have to be in the office from a certain time to a certain time. You would deal with the clients because you prepare a lot of the paperwork. You are the person who does all the background. You don't necessarily go to court, but you do a lot of document writing. So if you want to be a solicitor, you're the sort of person who has very good attention to detail, who likes drafting documents. They don't necessarily like to be arguing in contentious environment, which is what a barrister will do. And there's a lot of competition because jobs as a solicitor, if you get a good training contract, are more lucrative than in many other professions. And the salary increase in a solicitor career is quite high. Now, the barrister in the UK is the one that goes to court. So I had a picture in the back. Oh, here. So the barrister here in this one is the one who wearing the wig. because they go to court, they speak in court, and in the UK, we still have this very old-fashioned dress style when it comes to the law, and the solicitor is the one wearing the suit. So the barrister is self-employed, which means that you don't get a salary that is guaranteed. You get paid depending on how many clients you have and how many people you defend. So as a barrister, you can make a lot of money because you have very high-profile clients, or you can make very little money because you don't have very high-profile clients. And if you're defending people in court, so criminals or young offenders, it's not quite as lucrative. So there's quite a big range between being a barrister and a solicitor. And also, you get paid by clients. So if you don't have any clients, because maybe the country is on lockdown, you probably will struggle more than a solicitor would. So a barrister requires somebody who likes to take risks, knowing that some months they will make lots of money and some months they might make no money. But the good thing is that they have a lot of independence. So they set their own hours, so they don't have to be in an office from 9 to 5 like solicitors do. But they probably have to work really hard when they have a case and they have to defend a particular situation. Now, even though they get paid by clients, they are less close to clients because their main job is not to prepare all the documents. The solicitor would do that. Their job is to present the case in court. So you would have a situation, if you're taking someone to court, you probably have a solicitor that you meet with, that they draft the letters, they gather all the evidence, they talk to you. And then when the case is ready, they pass it on to a barrister who presents it in front of the judge and in front of the jury. And there's a lot of competition because it's a contentious environment. And this is the sort of thing you would see on TV of people arguing the case. You get to win and lose. So different personalities, different skill levels, and the profession is divided. In most countries, it is one profession. A solicitor and a barrister are the same. And this is where we hear the term lawyer. But in the UK, because the profession is separate, we talk about solicitors and barristers. Now, in order to qualify in the UK, so there's two routes you can take. So first, you do your LLB, which is your law degree. There's other routes of qualifying without a law degree. You can do a conversion course, but I'm just going to focus on the law degree version here. But if you have questions about the other routes, which is what my student Zara is doing, I can answer that at the end. So you do your law degree. If you want to be a solicitor, you then do something called the legal practice course, which is very practical guidance on what a solicitor does day to day. So how to draft a good contract. So yes, I said that a contract didn't have to be in writing, but there is a lot of problems that happen if you don't know the terms of a contract. So most of the time it will be in writing. So you want to make sure that the contract is right. You make sure, how do you initiate a lawsuit? How do you put the documents together? You know, how it's very much practical on what it's like to be a solicitor. After that, you apply for something called a training contract. And this is incredibly competitive. This is and it's very challenging for somebody who is an international student, because you need to be have the right to work in the UK before you can apply for a training contract. So the training contract is a 2-year training. So you have every 6 months a training in a different seat, is what they call it. So you get trained in perhaps one area of law, depending on which law firm you go to. And then at the end of 2 years, you are a fully qualified lawyer or a solicitor, and you can work and practice anywhere in England. Then the other option is to become a barrister. And so the barrister have a similar, so the bar professional training course, which is the practical aspect of studying as a barrister, and they learn how to present in court. There is quite a bit of different procedures and ceremonies that come with speaking in court, who stands up first, all of these things they learn in the bar professional training course. And then they're qualified as a barrister. And then after they're qualified as a barrister, they do a 1-year pupillage. And so a pupillage is not quite as lucrative as a training contract. So when you're doing the training contract, you get paid quite well. As a pupil, it's more like work experience. You don't get paid as well, and you sort of job shadow a barrister. Go with them to court, take notes for them, do a number of different activities that will help you train. After you finish your pupillage, then you are qualified as a barrister, and you have what we call the rights of audience, meaning that you have the right to speak in court. Now, there are some solicitors that do have the right to speak in court because they can apply for rights of audience later on in their career, and so there is a lot of merging of the professions in the current situation, in the current times, and there's a lot of talk as to what this division is quite arbitrary and shouldn't exist, and that they should bring them together, but that hasn't happened yet. So at the moment, we still have two very different situations of barrister and solicitor. Now, in order to get into a law degree at university, you need to have A levels. You'll usually need the minimum of 2 A levels. Although they say a minimum of 2 A levels, in reality, most university courses for law will require 3 A levels for the most popular courses. And the grades that you need at A level will range anywhere from BCC to AAA, depending on the level of university you want to gain. A-level law, as I said, is not a requirement. However, if you are planning on studying law at university, trust me, you will be so grateful that you've done it, because it will make your law degree much easier. And I really, really wish I had done it, because I wouldn't have struggled so much in those first 6 months, which are quite challenging, because I would have had such good foundation. In my law degree, I had to learn a lot of things through work experience by myself, and catch up with things that I didn't know, that didn't teach in the law degree. So if you can, and if you're definitely planning of studying law at university, I highly recommend this course. Now, most law universities will accept any course. However, you have to do your research, and this is something your director of studies at MPW will help you with. There are certain subjects that they don't accept, so things like PE, photography, art. Now, that's not all universities. Some universities are perfectly happy taking someone with an art A level or a photography A level to do law, because a law degree is great. Even if you want to study art, or if you want to study business, it's a very good degree to have. But it's important that you check beforehand, because each university and each department will have different requirements. But that's something your director of studies at MPW would be able to help you with. So you also need to have a good level of English and maths to do, or equivalent if you are from another country, to be able to join a law degree. Sorry, my screen. All right, so that pretty much is it for me. I don't like to be doing a lot of the lecturing, but hopefully you found that sufficiently interactive. Are there any questions that you would like to ask me at this stage?
Thank you very much, Jessie. Beatrice asks, could you please explain a little bit more about the GDL and LLM?
Okay. So there is another option that you could do another degree, which is what I did. I did a politics and media degree first, and then you can do something called a law conversion course. And there are two options to do a law conversion course. You can either do a 2-year law conversion course, or you can do a 1 year, which is the RGDL, a 1-year law conversion course. Now, the reason I did a 2-year law conversion course is because my plan initially was to go back to Canada, and in order to qualify as a solicitor or a lawyer in Canada, they would prefer for me to do the 2-year one, so then I only need to do 1 year back in Canada. The law degree in the US and in Canada works differently, because they expect you to do an undergraduate degree and then do a law degree at postgraduate level. In the UK, it's different, because it's the only, I don't know if it's the only country, actually, Australia as well. You can do a law degree as an undergraduate, so you go straight out of school into the law degree. and it's only 3 years. But the catch in the UK is that after those 3 years, you also have to do the LPC and the training contract, which takes 3 years in the end. So depending on what you want to do, you have to research, or depending on where you want to practice. The GDL, it's a good program. It is very tough though, because you do all the required subjects in 1 year. And if you're doing tort, contract, public law, all of those subjects are quite heavy, and to do them in 1 year is quite tough. But if you do not know what you want to study, and in fact, if you want to be a lawyer, actually, I recommend also doing a different degree, because a lot of law firms prefer people who have done maths or science or other degrees, because it allows them to work in different fields. So it's important to think about what you want to do as a career, and then do the research, and your director of studies will be able to help with that. Does that answer your question?
Okay, so I'll go on to the next question as well, which again comes from Beatrice, and says, so to what extent does the university you go to affect your future pathway? By that she means if a university that accepts BCC in the A levels, would that in time allow you to get a good solicitor, go to a good solicitor's firm, or find a pupillage?
Okay. So in theory, the university you go to shouldn't have an impact on your ability to get a training contract, because it is based on your grades. So getting excellent grades for a not so good university, it should be the same as getting excellent grades for a top university. However, when you look at the statistics, and the likelihood of getting a top training contract, so the best, there's something called the magic circle firms, which are the top firms in the country, and the majority of people who end up going there have degrees from Oxford and Cambridge. So you might think that going to a better, it's hard to know whether it's the better university that caused that to happen, or is it that better students go to better universities, therefore they get better jobs. So in theory, it shouldn't matter, but I think in practice, it probably does. So my advice to you would be, try to get the best possible grades to go to the best possible university. But if you don't end up going to the best possible university, then do your best or whatever university you go to, because it's perfectly possible to get, a first for a mid-ranking university and still do quite well in the field if that is what you want. But also, I would say also do your research, do a lot of work experience. For example, I did work experience during my law degree. That's what I spent a lot of time at the court. So I thought I wanted to be defending young offenders. And once I did it and spent time in the criminal court, I realized that that's not what I wanted to do. I'd rather be teaching about law than practicing it. So do your research, make sure that law might seem really interesting on television, but the reality of it is very different. So if you know anybody who practices law, just say, I want to spend a day with you. I want to find out what it's like to be a lawyer before you make that commitment to go in a particular way.
Okay, thank you. And Jessie, could you please recommend a good subject combination, please? So A-level subjects that would help students.
A good A-level subject combination. I think politics and law go really well together, because there's a little bit of overlap. Not a great deal, but there's a little bit of overlap. And business as well. So if you are unsure, you know that you want to be inside of the corporate world, but you're not sure. So politics, business and law, or economics, politics and law would be a good combination as well.
And sort of, what about subjects like history? Does that help?
Yes,
because obviously, if we're looking at top universities, those that are wanting to apply to Oxbridge, KCL, the top institutions, would they be looking for the facilitating subjects? So history,
yes,
economics.
Okay, this notion of facilitating subjects tended to be quite quite important a few years ago. So everybody wanted to do the facilitating subjects. In my experience, because I'm also a director of studies, helping students apply for university, that there doesn't seem to be quite as much of an emphasis in facilitating subjects anymore. It's useful to have a traditional subject just because it gives you more options in terms of flexibility of which courses you do. So it is unusual the university says, oh, you need to have an A-level in history. It's possible, but I haven't come across that many universities in the social sciences, particularly like that. It's different for chemistry and maths, where they do have specific requirements. But in the social sciences, in the humanities, they just tend to say, 3 A-levels, and they might have a few that they don't like. History is a good subject, so is philosophy, but it's hard to give individualized advice, because the best thing is always go to the universities you think you might want. Maybe go to the top you think. Let's say if you want to study art, or if you want to study law, go to the top university. So let's look at the website for Oxford, Cambridge. What do they require? And then make your decisions for that. You might not end up at the top one, but if at least you have the requirements for the top one, you'll have the requirements for the rest.
Okay, thank you. So we do have another question. So to be a barrister and or solicitor, who will study longer, or is it the same amount of time? So a 3-year LLB?
Whether you want to be you will probably study longer as a barrister, because the training contract is 2 years, where the pupillage is only 1. But I think they are both equally demanding. Probably being a barrister is slightly more demanding, because you need higher grades to get into the bar course than you do the solicitor course. So you need a 2-2 to get into the LPC, which is the training course after law degree for solicitors, but you usually need a 2-1 or a first to get into the bar course. But
ultimately, they still do a 3-year LLB.
Yes, they still do a 3-year LLB, unless they decided to do another degree, a law conversion, which could be 2 or 1 year, depending on what they said.
Great, thank you. And Wheeling says, is an advocate, so the term advocate, is that a barrister or is it a solicitor?
Okay, so an advocate, sometimes what happens is you have a solicitor who gets an advocacy training, and the advocacy training gives them rights to speak in court. So it's technically a solicitor who's done additional training to be able to act in the capacity of a barrister to a limited extent. So they have rights of audience and they can speak in court.
Okay, great, thank you. And we have a question from Dewi. Hi, Dewi. So he says, do students need to take the EPQ? Well, and Rebecca also asks about the EPQ.
The EPQ is optional, and I think that it is a great program to do. But my advice to students is always, if you are doing your A-levels and you're doing brilliantly in those A-levels and you are comfortably performing on those, then you can do the EPQ to show the extra commitment. But if you are sort of just about managing the A-levels, I wouldn't recommend that you do an EPQ, because the most important thing is to get those good grades on the A-level. The EPQ only adds extra if you already have good grades. Most universities like it, but it's not a requirement. So I recommend it for students who are doing really well, who are very confident on their A-levels and want to have that extra mile, particularly those who want to go to Oxford and Cambridge. It looks great on the CV, but it doesn't look great if you have a fantastic EPQ but end up with 3 Ds at A-level.
Okay, thank you. Question from Daniel, who says, what proportion of international students do not get a training contract, and what can they do in that situation? Is it perhaps risky, therefore, for an international student to come to the UK and study law?
A very, very high proportion of students, I don't know the number off the top of my head, but the very, very high proportion of students do not get a training contract, not just international, but domestics as well. So I think that it's quite risky. I'm not going to lie to you. It is a risky course to if you want to become a solicitor in the UK, particularly as an international student, because you will have that extra barrier of having to have the right to work in the UK before they can hire you for a training contract. What I would say to you is the law degree is a very versatile degree. So you can use it for anything. And in most jobs and most careers, they don't expect you to have a specific degree, including law. You don't necessarily need to have a law degree to study law, because you can apply to a training contract after a business degree. And what a lot of law firms would do is that if they like you, they will sponsor you to do the 1-year conversion course and then the LPC if you're really good and they really want to. But it is quite competitive, and there's no point of saying that. Very competitive, and there's a lot more law graduates than there are training contracts.
Okay, and so Daniel says as well, is there no equivalent of LPC or bar than 2-year training contract in the US or Canada? Because you mentioned the comparison and the catch being the LPC and training contract.
Yes, so if I wanted to go back to Canada after doing the law degree in the UK, they wanted me to have the 2-year course, then I would have to do a 1-year course, and then you go through some different training. The rules may have changed since then. I don't know them off the top of my head, but there's something we could explore individually if you like. In the US, different states have different laws, so you would have to actually look what the laws are in a particular state. A lot of people will have to do what is the bar exam, so you pass one exam. Incidentally, the process in the UK is changing, so the university you go to become less important, because after your law degree, everybody will be required to do a single exam to become a solicitor. So that would equalize the achievement. So going to a top university will become less important then, but until that changes, we're still under the old system. So to answer the question shortly, yes, you can transfer with a law degree to the US and to Canada, but you need to do research to the specific province and the specific state to make sure that you're doing the right things. And the law is changing all the time, so you have to be sort of doing the research yourself, but we can help. The director of studies can help.
Great, thank you, Jessie. And a question from Beatrice, who says, are there solicitors exams in the UK, or is it only practice?
At the moment, there is no solicitor exams, but one of them is being, so it's just your university exams. But at the moment, there is a solicitor exam that is under development. Probably by the time you graduate, that will be the way that it will go forward. At the moment, we're still operating towards the old system, and there is a transition period, which I'm not really sure how it will work. But there is an exam is expected, but it's not quite there yet.
Okay, great, thank you. Do we have any other questions? We'll just wait a few moments.
Sorry, I did say I was going to put my camera back on. So there.
It doesn't look like we do have any other questions at the moment. So thank you all for joining us, and thank you very much, Jessie, for holding this session today. If you do have any questions later on, please feel free to email international@mpw.ac.uk, and Jessie and I will get back to you with any answers to questions you may have. Jessie, did you just want to have a final goodbye, and then we can? Okay, so just a reminder, everybody, our next webinar will be next week, and it's quite an exciting one. It's the first time we're doing an art workshop, and that's on Wednesday the 13th at 9 AM. Please register for that one. And then we also have a personal statement workshop at 10 AM on Thursday the 14th. So please do join us for those two workshops next week. Thank you very much for joining us today. This session is recorded, and we will send you the presentation and the recording of this session. Stay safe, everybody, and thank you so much again for joining us. Bye-bye.
It's lovely to see you all. Bye.
Thank you very much.